This week, a hour-long coronavirus question and answer hosted by Erica Peterson of Wedding Network Seattle.
This is the Wedding Industry Law Podcast, a podcast dedicated to wedding professionals that are just trying to keep it legal. And now, your host, Rob Shank.
Hi there. Thank you very much for listening. Hope that you have been enjoying the content thus far. This would be, I think we're at episode 4 at this point. I wanted to put more information out there regarding coronavirus and COVID-19 and postponements, cancellations, these type of things going on in the world right now. I think that the more information I can put out there, the better. This episode, I'm essentially going to be putting out there a webinar that I did with the fine folks over at Wedding Network Seattle. The host of that webinar was Erica Peterson of Planning Savvy. I'm very happy to come on and do that with them. They're always fine people, awesome folks up there. So that took place on Thursday, I believe March 25th. Yep. So that aired or went live March 25th with them on that wedding seminar. And so now I'm putting it forward on my podcast. It's about an hour long, lots of questions. If you're watching this, it's going to be blank screen because I could not figure out how to get the audio and the video to sync. There's some kind of issue with that. So, but if you're listening, I guess it doesn't matter then. A couple of things really quick before we get into the content. Number one, if you are in a situation, which I'm pretty sure that you probably are, where you need to postpone an event because the coronavirus has prevented that event from going forward, my company, WedForms LLC, is giving away free contract amendment templates for the coronavirus. To get those, just email me at rob@wedforms.com. That's rob at wedformz.com to get yours. Just say, hey, let me get that coronavirus thing. Not the coronavirus, just the template. So I'm giving those away, no strings attached. I'm not keeping your emails. I'm not secretly getting your emails and putting you on a list. I hate emails. Very much. So you will not be getting an email from me other than this contract template and the guide on how to use it. The disclaimer on that is that I cannot draft a contract amendment for every single person specifically. These are broad. So you'll want to have somebody look at it and you'll want to make your own changes to it. But this is, I think, an excellent starting point for you. The next thing is I am attempting to understand how YouTube Live, YouTube, and Instagram Live and Instagram TV work. So if you could be so kind as to follow me on Instagram, I am at Wedding Lawyer on Instagram. I'm not sure how YouTube works. I think just look for the Wedding Lawyer on YouTube, and I think that you'll find me. I guess get that information back out. Anyway, get the contract template for me by emailing me. Please show me some love on Instagram. Please subscribe to this podcast if you enjoy the content, and most of all, please share this content if you think it would be helpful to someone else that you know in the industry. And with that, we'll go ahead and put on the seminar. This is me, question and answer seminar with the Wedding Network Seattle, hosted by Erica Peterson. We're in the middle of a pandemic. Okay, we are in a situation where it is becoming unlawful to get into a room with more than 1 or 2 or 3 or 4, 10 people. Okay. If you attempt to throw a house party or a block party, the Department of Health or the governor or the sheriff is going to shut you down. So how does this work in terms of your legal obligations to the client's legal obligations to you? If you have a written contract with your client, the chances are that there is going to be a provision in that contract that is called the force majeure clause. If you don't have one, we can talk about that a little bit later. But you probably do have one because it's just a boilerplate provision that's pretty much in most contracts. The force majeure provision is in there for when an event, typically an act of God, usually it's weather related, but it's in there in the event that some type of higher force outside of your control as a wedding professional, outside of the control of the client, makes it impossible or impractical to complete the contract as it's written. So examples other than a pandemic, and we'll talk about that in a second, examples of that would be a few years ago when the federal government shut down due to the budget. If you had an event in a federal park, you couldn't go in there because they were closed. That is going to be a force majeure event, typically. Typically, if a fire burns a venue down, you obviously cannot have a wedding at a venue when it's just smoking ashes. Okay. That's typically a force majeure event. Tornadoes, hurricanes, these are your typical acts of God that would make it impractical or impossible to go forward with the event. So what the force majeure clause does, if there is in fact a force majeure event, is typically, and again, I haven't read yours, but typically, the force majeure clause, if there is a force majeure event, requires the parties to do what they can to complete the contract once the force majeure event has dissipated, once the force majeure event has terminated. So when you have the federal government shutting down, the parties are going, okay, well, we can't have the thing at Yellowstone Park or Alcatraz right now, but that budget shortfall is not going to last forever. So let's work to postpone it and rebook it and follow through with the contract at a time when the federal parks are not shut down. Let's try to I I see a hand going up. You literally the only person that I can see, and I feel like I'm staring right at you. Hello. I can't hear you though. So if you're saying anything, I can't hear you.
I have a quick question on the force majeure. How long does that last? Is it indefinitely until we can reschedule, or is it within a year?
Okay, so excellent question, Rebecca. So many contracts will have that in it. So some force majeure clauses will say the parties will work to reschedule the event in the next year, 6 months, 9 months. Okay. So what happens if your contract does not have that language? Most of the time, the law is going to apply the worst word ever, and that is reasonability. What is reasonable under the circumstances? So my feeling on this is that if we were in a situation where the venue burned down, that's a different reasonability than when the entire country is in a state of pandemic, right? So in the event of the venue burning down, or in the event that a hurricane is there, you might not need a year or 2 years to be reasonable to rebook the date, postponing the date and going to another one. When it's a nationwide pandemic where everybody's wedding is canceled across the country, I would argue, because there's no bright line test, like nobody can answer this, but the arguments that are going to be made in this instance is, well, let's look towards a year from now. Let's look towards 18 months from now. Okay, because not only are we having to rebook every wedding for the next 6 weeks, we're also people aren't going to stop getting married. So we're still taking in more clients, and there's only a finite amount of dates. So the answer to the question is how long do you have? It's with whatever a judge down the road is going to, or jury is going to say is reasonable. And I would argue to you that because we are in a pandemic situation, that got not a whole lot, probably got a little bit more lenient on what's reasonable, what's not reasonable, if that makes any sense. Perhaps if the force majeure event was a flood, it's like, well, let's just wait till the water's low and then we'll have it. No problem. 6 weeks, 6 months. This situation, I think that we're looking at, because it's unprecedented, who knows? But I would say that it's not out of the ordinary for it to be over a year from now. Okay, so great question. So circling back, you have a contract, you have a force majeure provision, you're using reasonable efforts to rebook the date because the date is postponed and the client's working with you. That's what's required typically under the law. You both need to work reasonably. I get some calls, not very many, but sometimes the person is literally using this pandemic just because they want their money back. It's like, oh, well, if anything as good has happened, I'm out of this thing now. This gives me excuse. They have to at least make reasonable steps to rebook that date with you. Okay. All right. So let's say that neither of you are able to do the thing within the next 6 months, 9 months, year and a half, whatever it is. You both, it's unable to happen. What happens then? Typically, without reading the language of your specific contract. Can everybody hear me okay? Are we good? Okay. So without seeing your specific contract, what happens then? Typically under the law, everybody has to go back to where they were before the contract was signed. That's called status quo ante. That means that the client gets their money back and you don't have to perform. So that's a huge bummer. That's bad news brown, okay? Because you've got 20 or 30, 15, luckily if you got a whole bunch, your cash flow is going to be shot, okay? Because that's how it works. That's why, and we don't have to do it here. I'm not a business person. I'm a lawyer, but you have to use as much honey as possible to get those clients to rebook the dates, whether it's got to be a Friday wedding, a Sunday wedding, you give them a break just to keep your cash flow going. But that's typically how it works. Some jurisdictions you can keep expenses and out-of-pocket things because you don't want to be worse off than you were. But that's going to be jurisdictional and it's going to be tough. Okay. So I've heard some professionals that are saying, well, I shouldn't have to give any money back because I was ready, willing, and able to go forward with this, and it's not my fault that it's a pandemic. Okay, that's great. But if the client sues you, which they might, you're not going to look very sympathetic in front of a judge and jury that during a pandemic you weren't willing to work with them, and also vice versa. To the extent that any client is like, hey, you need to show up and coordinate my wedding next week, even and don't worry about the sheriff coming and getting you, that's going to look real bad in front of a judge as well. Okay, so what can you do then? Okay, if it can't be postponed, if you have made reasonable steps, which you're typically required to do, to rebook the date, what happens then? Is it something like I gotta just empty my bank account and give it back to you, give it back to the client? Again, there's no bright line rule, and I would argue what is reasonable in a situation like this. This isn't a situation like a typical force majeure event, which is only affecting one wedding. This is a force majeure event that's theoretically affecting the entire world. I can't go to the gym anymore. I mean, my wife yells at me if I'm going to go to Kroger, I should use Instacart instead. When I get home with the groceries, I got to wipe them all down with disinfectant. This is unprecedented. I don't have to tell you all that. So what's reasonable in that situation if you have to give the money back? I would be willing to argue to you that it's going to be like, hey, listen, I can give you 20% now, 30% 60 days from now, some type of timeline that's not 100% back right now. Because or the client can say, or the client, I'm sorry, you could say to the client, if I give all my money back right now, I'm going to go bankrupt, and maybe you'll be the first one in line that's getting that money back, and maybe you're the last person when there's no money left. So this is not necessarily take it or leave it, because again, you want to try to rebook these dates, but the client also has to meet you halfway too, if that's the situation where it's not just one wedding for you or 2 or 3 weddings for you, but it's a substantial amount, and refunding all that money back would result in bankruptcy or financial ruin for you. I would argue that it's better for you as a going concern to remain open as a business. So saying, listen, the best that I can do is give you this much now, this much then, this much. Do that. Because what'll happen then is, and Erica, just let me know if I'm rambling on. Like if you, I don't know if you can hear me. Yeah, obviously you can hear me. Okay, just you can stop me if I'm. But anyway,
No
If
problem. I figured I'd let you finish this one and then I can go in and we can just start asking questions and go in from one to the next.
fantastic. Okay. So
Okay.
it's better for you. Thank you. It's better for you as a going concern to remain open. And if that means staggering out these refunds to the different clients, then that's what you're going to have to do. And I guess what I was going to say is that if you've got one client that wants to sue you for that, that's going to say, I want my money back right now, and they sue you, they are going to have to go in front of a judge and go, Your Honor, he or she told me that I was only going to get 20, 30% this day, 30% this day. And the judge is going to go, are you crazy? We're in the middle of a pandemic. Like, be lucky that you're getting any money back and that they didn't go bankrupt. That's what I would argue is going to happen if they want to fight you on that. I can't, there's nothing that I'm going to be able to tell you tonight that is going to put a shield around you and prevent you from being sued for something. People are going to sue you for the dumbest crap. There's nothing you can do. There's no contract that's going to keep you from being sued. The contract is there to make it harder for them to do it and make them look stupid. But there's something I can tell you that you unfortunately, statistically, one of y'all somebody's going to get taken to small claims court. That's just statistically, that's how it's going to work. And it sucks. That's just how it goes. But on the flip side of that, again, sum up, if you got a force majeure clause in there, I guess we didn't talk about whether or not the pandemic is a force majeure clause. Like, some of you might have the question of like, well, Rob, my the clause in my contract doesn't specifically say pandemic. Is that an act of God? Is that a force majeure event? The answer is there's no bright line rule, but if the local government, state government or federal government is by law, edict, proclamation preventing the parties from going forward with that contract, and there's no way around that, then I think that you've got a pretty strong argument that that's a force majeure event. And even, I guess, at the end of the day, your contract can't be 600 pages long. So force majeure clauses typically list like the most common occurrences, the most common force majeure events. So just because something isn't listed there, if aliens came down and blew up Independence Day style the venue that you have, it's probably a force majeure event, even though alien invasion isn't written in that force majeure clause, if that makes any sense. So is pandemic a force majeure event? There's no bright line rule, jurisdictional, but probably yes. I would almost be willing to bet, and I probably shouldn't say that because I'll get in trouble with the law, my bar license, but it is, probably is. Okay, so Erica, let's you can
Yes.
add whatever we want to do.
Okay. Since you're on this topic, we did have a couple of questions that were specifically regarding what you were just talking about. So I want to ask one of those right now. What about for planners who have already done a lot of the work in advance? How can we work around that? Where we have like, specific like payments that we have charged already, or, we've done a certain amount of work, like payment that we've already requested, said so much is paid now, so much at this time, and we've already done a lot of the work. It's unlike, let's say, a florist who, the flowers come on the day of, or a cake that comes on the day of. We've already done a lot of the work. So if somebody's asking for, for their money back, and we've already done a lot of the work up to the day of the wedding, and they're asking for money back, how can we work around that? Saying, well, we've already done a lot of the work. The day of is only a part of the work that we do. So
Sure.
how do we do that?
Sure. Okay. So I'm making the assumption that we're right along with you. You're a planner or coordinator. You've already done a lot of your services, like you've found the venue, you've done the walkthroughs, you've coordinated, you found all the vendors, you've done all these things that require your brain and your creativity and intelligence as the planner. That's part of your services. You've already done that.
Mm-hmm.
If that's all you've done, then it's possible that under some theories of law, I think that you could argue, sometimes it's called quantum meruit, like if you want to get super Latin on it, but you could argue, hey, look, client, I've done these things. There's a possibility that I could be compensated at an hourly rate for that, whatever a judge would decide is fair. But I don't think that's in today's circumstances, I'm not quite sure how successful that would be. So that's why, and again, we're just talking about the services right now, no out of pocket. We're just literally just talking about your brain power and the services you've rendered. I think that would be a hard argument to make it. Is it impossible? No. That's what I'm saying. It's jurisdictional. When you have to go back to status quo ante, the way you were before the contract started, that's just how it works. I think that from just a customer relation standpoint, that's why it's imperative to try to postpone and rebook that date. If you cannot, if it's impossible, even though you've done all that work as a planner, then I would suggest that you try to negotiate with that client for whatever expenses. Try to get it in writing in terms of, listen, this is what I'm out of pocket. So accept this, here's the rest, or whatever the case may be. You try to work something out like that. And it's unfortunate, but the only person that's going to be able to tell you definitively what you owe that person is going to be a judge or a jury down the road. And you don't want that. You want to stay clear of that situation. Will the law support you keeping expenses? Maybe. Will the law support you in a quantum merit claim, meaning I want to get paid for some of the work that I've done? Possibly, but it might not be worth it. It might not be worth that, because you're going to get flamed, because yeah, you might have done some of that stuff, but the client hasn't received the benefit of it. And if the client's got to go back to where they were, you got to go back to where you were. That's kind of how it works out. Hopefully, if you're a planner or coordinator and you've done all that work, they're going to retain you again for the new date, hopefully. And if they don't, then you, and again, I'm not a business person, I'm a lawyer, but you would need to do the cost benefit analysis of like, well, I'm not available for the date they want. Okay, well, if you're going to be out of pocket $10,000, how much are you going to make on this new one? Don't book the new date, or make sure that you do something that you can on a cost benefit analysis to not lose out on that, is kind of what I'm saying.
Okay. All right. So there are some ways around it. We can definitely use that. All right. So I'm going to go up, people, and start with some of our other questions here. Let me go. I'm just going down the list here because I know that you did go through quite a few of these. So one of the questions is, I have verbiage about cancellation and termination of contract or termination of agreement in my contract. However, I do not have any verbiage about rescheduling. Can I add an addendum to my contract to incorporate this? And what is the best way to go about this, as well as communicating it to my clients?
The direct answer to that is yes. It just depends on where you're at. So moving forward with new clients, you can do whatever you want, because you're forming a new contract with somebody. But you can't just unilaterally change the contract once it's signed. So if I understand that question correctly, so I guess the issue here is like cancellations and keeping money and keeping deposits or retainers or whatever you want to call them. Typically, the language in your contract is you keep that money if the client cancels for reasons that it's within their control. So the groom is, hanging out with the bridesmaid, or, maybe they just don't like each other anymore, and engagements end. That's typically when that contract provision kicks in, where you keep the money and everybody goes your separate ways. Again, this is an instance in which the reason why the contract can't go forward is because of a reason that's outside of the control of the client. So whatever contract language you have that says this is a non-refundable, or this is I get to keep this deposit if you cancel the contract, typically that is superseded and not voided, but that's, if it's a force majeure event, you go to the force majeure event clause first. So in other words, if a pandemic prevents you from going forward, or if any other force majeure event prevents you from going forward, it's not the client that's canceling the event. Yahweh did it. So it might not be safe. You might not be on safe ground if you want to have an addendum, or you want to say now that, well, my contract says I've got a non-refundable deposit. The judge might tear that up. And I hope that I answered that question is the way it needed to be.
Okay. How do we legally add an additional clause to a contract? And what if our clients do not agree to the additional terms that we've added after contract is already in place?
Excellent question. So addendums, amendment, new contracts, whatever you want to call it, you can do that all day long. You can add whatever you want to any contract as long as it's mutually agreed. So all a contract really is, in a basic standpoint, is an exchange of promises. I promise to deliver flowers to your wedding, and you promise to give me $5,000. And once you have agreed, we each have that offer, and they accept it, you have legally binding promises, legally binding obligations. And you cannot add or detract from those obligations unless there is also mutual agreement. So in other words, you can't say, all right, I will bring flowers to your wedding, you will give me $5,000, and then later on go, you need to give me $10,000. That's unilateral, not mutual. So how do you do that? You do it by saying, listen, and people are doing this thousands of times a day, really. Okay, guy, we are working to rebook this date. How's, September 18th? Sounds great. You've just amended the contract because you've said, all right, obviously we can't do it on this date because of the pandemic. How about September 18th? And they say, yes, September 18th sounds great. So you theoretically have amended your contract to change the date. Everything else rides with it. Typically, everything else rides with it. So my recommendation for amending your contract in this situation is to A, have it in writing, and B, have it in writing, B, make sure that whatever alterations, not just the date, but whatever alterations that are happening. So for example, like maybe there's going to be added expenses, maybe, I don't know, like whatever is different in services or price about the new date is put into that amendment or that addendum or the new contract, whatever you want to call it. So it's in writing, you've got all the new things in there, and you got to make sure that both of you agree to it in some form, whether it's an e-signature, an actual signature, a response in an email that says that's great, a text that says fantastic, I agree to that. That's how you would amend a contract in this situation if you need to postpone the date. And again, I am making a template available to everybody, specifically for the coronavirus.
Great.
You just email it to you. Email me, rob@wedforms.com, WEDFORMZ.com, and I will send it to you. The main thing I want to stress to you is that you still need to fine tune. You need to still fine tune it. It's just a template. It's designed for any state, and because it's designed for any state, it's not designed for your state. So you will still need to look at it. And make changes to it. But it addresses those things. It makes sure that both parties are in agreement to what changes, not just the date, to changes to the prices or services. It also addresses the idea that this potentially could happen again, depending on how far in advance you're rebooking the date.
Okay, great. And that does answer one of the other questions that we had. So that's perfect regarding the verbiage to use in the force majeure clause. So I think that that'll be perfect if we, and I'm, everybody right now, I'm sending you, if you look at the very top of your screen, there's a little chat bubble. If you haven't looked at it already, I just sent all of you in that chat bubble his email address, and you can email him directly. So you
I
can get that.
apologize about the rudimentary, like that you have to email it and it's not downloadable or something like that. I'm just not technologically savvy, and I had to do it like really quickly. So this is the easiest way. I promise that I'm not taking your email. I will never email you anything. I hate emails, so I'm not your information or anything like that. I just want you to have it. So
No, we
email.
understand. Thank you. Thank you, and I appreciate it. So there it is. Everybody should have that, and so it's in your little chat. Again, if you hit the little chat bubble at the top of the screen, it's there for you. Perfect. Okay, so another one is, should we have our potential or future clients always initial this new clause so that we draw this out and put more emphasis on the contract? Obviously, if we're going to be adding it as an addendum now, it's going to need to be signed around. But for future clients, do you suggest having like an initial next to it, the force majeure clause, especially during this crazy time during the pandemic? Would you suggest having people initial next to the force majeure clause to kind of draw it out so everybody is very aware of this?
Maybe. So let me explain that a little bit. So typically, one of the reasons why you see in different contracts like initial here, initial here, initial here, is because there are some concepts in the law, and every state is different, but there are concepts in the law that say, like, when you hide a clause in like really small print, sometimes a judge will go, that's not right, that's unconscionable, or that's inappropriate because you're purposely trying to prevent somebody from reading it. And so so there's a concept where that happens, where they'll strike through a clause because you intentionally try to hide it. And so kind of like the flip side of that, like to not fall victim to that, the individual that drafts the contract will be like, all right, punk, then let's do this. I'll make it huge. You have to initial it. You know what I'm saying? Like you have to, sign in triplicate. That's kind of like the opposite. So, when you make the client initial something, all you're really doing is just saying, all right, client, you know, you're acknowledging this, that it's so special that you have indicated that you have paid special attention to it, and you cannot later make the argument that this clause was so inconspicuous that you didn't realize it. In some states that almost never works, because like in Georgia, you have a duty to read. If you are illiterate, if you sign your name to it, you have agreed to everything in it. So, but all states are different, but that's really what you're doing. That's why, like when you buy a house, you're initialing everything, because the contract is like 30 pages. But your contract isn't 30 pages. Hopefully it's probably 2 pages or 3 pages. So the idea that you have inconspicuous or you've hidden something is a little bit harder for them to make. But I mean, whatever you can get the client to do it. If you have them initial it, that's fine with me. I mean, I'm not telling you not to do it. I'm just letting you know that's typically why that's done.
Great. I think again, this is going to be probably drawn out with your template. But if somebody is not going to use your template, I'm going to ask this, but how specific do we need to get with this clause? Do we need to be specific about location of the events, limitations in that area? I think every state is going to be a little bit different. Every city is going to be a little bit different. But I think this might be one that we just need to ask you right now.
That's a super excellent question. And that's what, like, I rack my brain for, because I mean, this is not something that, like, any lawyer that says I'm a master at force majeure, they're lying to you. Like, it's not something that comes up a lot. But that's a good question. So if you grab the template, fantastic. If you don't grab a template, that's cool too. If you don't, this is what you need to think about. First of all, we've learned our lesson. Put pandemic in there, okay? Just in case. Then what you can do, if you are rescheduling something in the next year, because I don't want to be the doomsayer, but we're not out of this. So if you're rescheduling something in the next 6 months, 9 months, 12 months, then I would even recommend that you define what a pandemic is, which is what this question is. So for example, you could say something like, force majeure, yada, 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 act of God, pandemic. For the purposes of the contract, pandemic means X, Y, and Z. And X, Y, and Z will be dependent on where you're at, but typically it can be something along the lines of, if the governor has issued a proclamation or a state, what's the word I'm looking for? You just used it earlier.
Shelter in place.
If there's a shelter in place order, in the county where the venue is, if there's a shelter in place, if the schools are out, you kind of set the parameter of when you want the force majeure event to have been triggered. But you also want to do something, you also want to go a little bit beyond that because of the nature of a pandemic. And the a tornado, I mean, it's like, okay, I can't, like, what do you want me to do? The tornado comes and a pandemic could possibly be, well, when do we want to say it's do or die? So you also want to consider a time frame. So if within 90 days of the event, the governor, the mayor, the city council has issued a shelter in place or a law that, or the CDC guidelines, no more than 10 people, if it's within 90 days, 60 days, or 30 days. So that way it's not the day before, or you're worrying about it 3 months before. You know what I'm saying? So like if you've made it to XYZ point, it's triggered, even though you might be freed up or it might be lifted the day before the event. So that way there's no guesswork prior. But those are the kind of things that I would recommend, is that you put pandemic in there, obviously, but then you define how you want pandemic to be triggered. Like I said, it can be by edict, proclamation, school system is closed, that kind of thing. Restaurants are closed, however you want to do it. And then a time frame for, when it's triggered, because it doesn't have to be that day. It can be the day before, the week before, the month before, 3 months before. So in other words, if there is a shelter in place with an indefinite amount of time, or the shelter in place at all within 60 days of the event, then we're not going forward on that date. Something along those lines.
Okay. And then also, given that, like in our state, the Department of Health, Human, Social Services, plus our local city, county, state departments, they put declarations for what events are allowed, not allowed to be performed. Should we put stipulations for those types of things as well in that clause, or should that be a separate clause in our contract, or a sub clause on that?
I mean, I can't recommend specifically what you should do literally, but like what I'm saying is that I don't know who calls the shot in Washington State. So if it's the Department of Community Health that makes the guidelines that you have to follow, then you can make the Department of Community Health the arbiter of whether or not a pandemic has occurred. Because 3 or 4 or 5 months from now, there might be a pandemic in Florida, but has no effect on Washington State. So you want, obviously, as local as you can get, if that's what you want, to be the arbiter of what's going on. I hope that makes sense, if that answered the question.
Sure, absolutely.
Okay. You're not just
what if it's
you don't really mean it?
Say that again.
I'm just kidding. I'm messing with you. It sounded like you were just saying, Rob, that's great. We'll on to the next one.
Oh, no, really, it is. And that definitely helps, because, for our state, we've had so many hands in it, I think, especially because our state has been kind of a, big focus with this whole situation. So we've had a lot of irons in the fire, let's say. So what if it's a personal call to not perform the event based on the circumstances of this pandemic? And how do we add that type of verbiage?
A good question, and I guess that's why I'm saying you want in your contract to say pandemic, for the purposes of this contract, will mean if CDC says this, Department of Community Health says this, federal government says this, or the parties mutually agree, because you're trying to not make it a personal call. And you definitely you definitely don't want a situation where it's like, hey, it's not a pandemic over here. You need to come in, you need to come and bring it. And you're like, no, man, it's a pandemic. Like you don't want that to happen. So that's what I'm saying. Like you leave it to an independent body to decide. But again, as always, like I said, if there's mutual agreement, you can decide whatever you want. So, but if there's a situation where you disagree, that's when you have a problem.
Okay. And then
And let me
kind of going off of that.
highlight that with an example that's not pandemic. So we rather, I had a contract with a core person that did a lot of massive outdoor events in southern Georgia, and for the the health of his workers, he made it where it was a force majeure event if the temperature with heat index got over 115 degrees by the National Weather Service for the county of where he was at. So it's not it rather than, if it's super hot, I'm not doing this, or if it's super hot, that's a force majeure event. That would make you have the personal choice of like, well, I personally think it's too hot. No, you're leaving it to an independent kind of judge to say what's hot, and it's the National Weather Service. In that, if the weather's over 115 degrees with the heat index, then it's a force majeure event. We have to reschedule.
Interesting. Okay. Okay. I can see where that would come into play. So kind of going off of that same situation, and I think you kind of touched on this already, but so let's say like a client is making a call to not perform an event based on circumstances of this pandemic, but how can you say, so they say, based on the pandemic, we have decided to cancel our contract. But how can you protect yourself so that so your clients aren't using this clause just to get out of an event? So for example, a wedding couple happens to break off their engagement, but they're saying or using this clause to cancel due to the coronavirus. They're canceling their wedding or canceling their do you understand what I'm saying? So how can you protect yourself so that it's not being used against you or negatively? Is there any way to do that?
Right. So let's address if that's happening now, and then we'll address how to avoid it in the future. So if that's happening now, it's tough because, I mean, the force majeure clause typically, I haven't read yours, but typically you are required to make a good faith effort to conclude the services in the contract at a time in which the force majeure event has subsided. So if they're just throwing up their hands and like, yes, happy day, I don't have to get married and I don't have to pay anybody anymore, that's not being reasonable out of the contract. So that's kind of like I don't have a good answer for that, because if you said to the client, you emailed me and made the mistake of saying we weren't going to get married anyway, but we're definitely not now that there's the pandemic, then you have a strong argument to say you're not acting reasonably to rebook this date. I'm keeping the money, and then they would have to sue you and then try to retract that statement, whatever, to judge, blah, blah, blah. And the only person that can say how much who owes the other would be a judge or a jury down the road. So if you have a client that is just using the pandemic to get out of the contract and they're not taking reasonable steps to rebook this event, then they're probably in breach of contract. And you would theoretically have a breach of contract claim against them. But in the climate right now, I think that would be tough to do. But would you be in the right for keeping the money? Maybe. I don't want to say probably, maybe. But only, I guess, if you had the evidence as I stated it, which is they are admitting to you that they don't want to rebook the date because they don't want to get married anymore. Then that's a different story. And it's possible that you would have a case for breach of contract in that instance, because they are canceling the contract for reasons other than the pandemic, if that makes sense. All right. Now, how does that square off in the future?
Right.
Well, again, you can, let me just say this, you don't want to have a contract that's 1,000 pages long. You want to have a contract that as best you can services the most common interactions and protects against the most common problems. That's why your contracts are probably 2 pages, 3 pages. They're not 50 pages. Could your contract be 50 pages? Absolutely, without a problem. It could be 50 pages, but no one's going to sign it. So how do we protect this in the future? You could add a few sentences in your force majeure that says reasonable efforts to rebook include X, Y, and Z, but you're adding things with when you have very valuable real estate that could go to other things that are probably a little more likely to protect you in the future. So if you wanted to protect against that, then that's how you could do it. You could say in your force majeure provision, we'll make reasonable efforts to rebook. Reasonable efforts include X, Y, and Z, and then whatever you would want to put. And that way you're literally spelling it out for them in the contract. These are the efforts that you have to make minimum before we cancel because of the force majeure event. We can't rebook.
Okay. Can we, let me see if there was a question before this. Okay, can we stipulate that it has to be rescheduled with us or a full payment is due? Like their wedding or event in the contract?
Can you, I'm
That,
sorry, I don't know if
sorry. Can we stipulate, like in the with this with the clause that if during the pandemic that they have to reschedule with us in order to that they will you'll not refund, that they have to reschedule if the force majeure clause it goes into effect, that you are requiring a reschedule rather than cancellation.
Okay, so I mean, I guess I would argue that the force majeure clause is an operation of law, is requiring the parties to try to reschedule. So again, you could have an extra stipulation there, like parties stipulate that they will make efforts to rebook. You could do that, but as a matter of law, typically the force majeure clause already does that.
Okay.
So
And I guess this
and then
one they had asked on this one, can they stipulate that or full payment is due? Like they're required to pay whatever they owe in full if they don't reschedule.
right, okay. I'm 100% on board with the question now. I was super confused for a second. Okay, so I guess the question is this: is it possible to shift the risk or assign the risk of a force majeure event to the client? I think it's possible. I think it's jurisdictional, and um, I would say that it's important to understand that for your jurisdiction. So when you get that template, and the template addresses this, you need to make sure that you talk to your local counsel. But I think that you have a good argument that if you require the client to get cancellation insurance, which covers acts of God and force majeure events, and the client is like, yes, I agree to that. I agree to get insurance. And then you make sure that you plainly state out that the client is assuming the risk of a force majeure event. And if you cannot rebook after reasonable efforts within an X amount of time, then you get to keep the money. Then I don't know if I think that that's allowable. I don't have case law to cite you on that. I don't have, you know, anecdotal evidence to show you that because this is unprecedented for me. But I don't see how a trial judge could look at a contract and go, all right, the client literally says, I'm assuming the risk of a force majeure event. And because I'm doing that, I'm going to get insurance that covers me for that. And as a result of that, the professional is keeping the money that they have. What's wrong with that? I think you have a strong argument for that if all of those things happen. I'm not guaranteeing that. That's not legal advice. You got to talk to somebody in your area because it's really jurisdictional specific. But I think that you have a strong argument if you've met those qualifications, that you're essentially saying you guys are taking the risk of any force majeure event in the future.
Okay, wonderful. I have one more question here that we had prior, and then I've got quite a few questions that have been popping into us. So let me ask this last one. And again, you touched on it briefly, but there's a little bit more to this. So how far out do you recommend these clauses cover? Do you put a limitation on time? There are pros and cons for both parties to have them and not to have them. So how do you make it reasonable, and how is that defined?
If I understand the question, how far out do you make the, like, is it how far out do you make it for the rescheduling?
Yeah, so yes, and then, for the force majeure clause in your contract and for a limitation for rescheduling, yes. So how far out would you
It's
make the rescheduling, whatever?
it's up to you as the wedding professional. Like, I mean, I don't think that it's going to be good if it's like less than like 6 weeks or something, especially for a pandemic. So like I've
Mhm.
seen as a common occurrence, I've seen 9 months, I've seen a year, I've seen 18 months as a common thing. As far as rescheduling, in terms of how far away to put the force majeure event, if I think that, anywhere between 30 and 90 days before the event, if the force majeure event kicks in, then that might be possible. There's not bright line. This is contract law. So you can pretty much
Right.
do what you want, but I would say that the industry, I don't even want to say industry standard, but typically what I see in terms of rebooking, it's a year.
So a year. Okay. That's great. That really helps. I am just making sure that I have everybody's questions here that everybody has sent to me and I haven't missed anything. I think that I've got everybody's copied down here. So if anybody else has a question, now is the time to send it to me in your little chat bubble so I have it, and I'm going to ask right now. So, and thank you for all of you that have sent questions. I have some really great ones here for Rob. So the first one, and I know I've already asked you about, but what about non-refundable retainers that people have in their contracts, have charged? Will those hold up?
Okay. So good question. When and this could, and that's what I'm saying, like I don't want to tread in dangerous grounds, but typically the money that you are accepting from a client that does not go back in the event that the client cancels for reasons within their control. That's what we're talking about right now. At least that's what I'm talking about right now. You keeping money if the client calls the wedding off for reasons that are within her control or his control. Sorry. Okay. If that's written into your contract that happens, in reality, what you have is what's called a liquidated damages clause. And what that essentially is you and the client agreeing, if it's written that way, you and the client are agreeing that rather than me go through the hassle of having to sue you, go before the judge, do all that stuff, and get a piece of paper that a judgment against you, all that kind of stuff, we're agreeing to just bypass all of that. And we're agreeing that I'm going to keep this money instead of suing you for breach of contract. That's kind of the exchange and consideration for the liquidated damages clause. Liquidated meaning a finite, a set amount of money, and damages being the legal word for money. So it's a finite amount of money that you keep in a limited set of circumstances that the client breaches the contract. So there are other ways the client can breach the contract that would not trigger that, depending on how your contract is written. I've recently in the past few weeks read, or at least since this thing, that you can't have non-refundable payments, you can't have non-refundable. That's not true. You can have those all day long and they're perfectly legal. So they're not a myth. I mean, I see them enforced my contracts have been enforced in courts, but they have to be written in certain ways for them to be legal. But absolutely, you can write a contract in a manner in which you keep money if they cancel for certain reasons. A force majeure event would not be one of those reasons, but yes, you can do that. Hopefully I answered the question. I can't remember what the question was. Sorry.
Non-refundable retainers.
Yeah, that's what I'm saying. So, and again, like, Rob, do I use retainer? Do I use deposit? Do I use installment? Do I use payments? Whatever it is. I would argue that I have yet to see a judge that is going to rip a contract up because the right word like that wasn't used. I think the most important thing. I hope that wasn't me. Okay. The most important thing is that that you define what happens in the event that you want to keep that money. Like, what are the parameters? What are the circumstances in which you are allowed to keep the money, and make sure that's spelled out. That's the most important thing, rather than worrying about whether or not you're calling it a retainer or what. There's a lot of misinformation about that on the internet, but I think that you'll be safe for the most part, depending on what state you're in, if you just define what happens with the money if they cancel the event.
Perfect. Okay. Another question here is, what do I do if the client did a chargeback on their credit card and took all their money back?
Well, if we're talking about the pandemic,
Yes.
then I mean, then yeah, I mean, everybody has to go back to where they were. They didn't give you an option to stagger the refunds out, and it leaves you high and dry. Hopefully that didn't happen a whole bunch. But I think that, again, not to retread all that, but typically everybody has to go back to where they were before. There are certain circumstances which you can keep expenses. I don't know if this individual is in that boat, but you're never going to get that money from that client. If you have a claim to that money, you can sue them, but that would be terrible. It's just, that's an unfortunate thing.
What about a pandemic that affects another state but not in your state, where guests and clients may be impacted and not able to come? Do you need to include language regarding this? And I think that I'm going to add, in a situation also where the pandemic is in our state and you have guests and clients and things like that can't come to your state, or if you are a vendor and you are doing you are traveling to a wedding as well. So this could be a situation for, I guess, a multi type situation. So how do you deal with the language in your contract with this?
Sure. Another great question. So, all right. Again, a force majeure clause does not have to literally list out every possible circumstance in which there's a force majeure event. The overall principle is, can the contract go forward with the parties? So, okay, fair enough. What does that mean then? Like, if nobody can come but the couple and the vendor, is that fulfilling this? Is that fulfilling the contract? I don't think so. Like, I think there's a strong argument to say that if, based on the fact that there is maybe a pandemic in state A but not in state B, and the wedding's in state B, so the vendor and the couple can go, but literally nobody else, there's a strong argument that that's in fact a force majeure event that's preventing them to go forward. I don't have a crystal ball. I mean, that's not something that's ever happened, and as far as I'm concerned, but you have a strong argument that that's a force majeure event. On the other end of the spectrum is, everybody makes it. That's not a force majeure event, even though state A has a pandemic and state B does not, where the state B being where the venue is. So the problem is somewhere in the middle, right? So how can we address this? Again, in order to not have to really deal with this as much in the future, You can say something along the lines of a pandemic also includes, or a force majeure also includes, if it is impracticable, it's impractical or impossible for X percentage of the attendees to make it. You can also do that. The only thing that I would say is, and I'm fully aware that I'm saying this to where you guys are, where your state and the impact of this pandemic on your state specifically. But you don't want your contract to be 100 pages long. So to the best of your ability, you try to get what's most likely to happen. So can you protect against that instance where, okay, what about this? If you can think of it, it can happen. But the issue is, how probable is it going to happen for it to be worth taking up that real estate in your contract? So I guess, again, to answer the question, yes, you could say the pandemic, a force majeure event occurs if it's going to prevent X percentage of the wedding attendees from attending, then that triggers a force majeure event. You could do that too.
Okay. Another question we have is, how can I help a couple who wants to reschedule a wedding date from, they have May 30th to later in the summer date due to the virus, the pandemic. The venue says, no, sorry, you signed for May 30th as a wedding. The couple has already paid the venue, already in full. What do they do if in this situation?
Okay, so in this situation, the person asking the question is a vendor other than the venue?
Yeah, so the venue is saying, no, sorry, you signed for this date, and the couple wants to reschedule it. They've already paid in full. The venue is saying, sorry.
But May 30th is the date.
May 30th is the date.
Where is it the venue at? Is it in Washington? I'm sorry.
Yes.
Okay. I don't know the current status of your shelter in place. Is it not till like May?
Right now it's through the end of the month. Schools are through the end of April closed, and things are TBD for everything else. I mean, right now there's a good chance that schools aren't going to go back, and so everything right now is getting pushed out. Most venues are pushing things out to end of May.
Okay. Well, I think that because you are in a shelter in place right now, which is preventing all the vendors from doing what they should be doing right now, like I'm specifically speaking of the planner and the coordinator, that's a good argument that the force majeure event, even though we don't know whether or not you're going to be on lockdown on May 30th, that it's already happened. That's why it's important to with a pandemic situation, that you set a date certain, like a do or die date, like within 90 days. It doesn't matter if it lifts, whatever, it's done. But in this instance, I think that the client would have a strong argument that a force majeure event has occurred, and depending on their contract, they might have a claim against them to get their money back or to reschedule. So
Right.
I think,
Okay.
I think that's probably super bad business, because, man, like, I'm not a soothsayer, but we're not out of this. And I mean, a lot of estimates are saying, May, June, July, we're still hopefully doing what we can to flatten the curve.
Right. What happens if you have no force majeure clause in your contract right now?
Okay, very good. I forgot to mention this. So, okay, typically, again, to sum up, I guess, typically the force majeure, it prevents people from suing each other for breach of contract because of something that prevents you from fulfilling the contract, reasons outside of your control. Second, it requires you to rebook it to try to because the contract's not canceled. The event might be canceled, but you got to put it or postponed, but the contract's not terminated, I should say, in that instance. Okay, so what if you don't have one? What happens then is that taking it to its logical conclusion, if the client says, okay, we don't have a force majeure event clause, we don't think there's a force majeure event, we want you to show up in the middle of the pandemic to do our wedding, take our wedding pictures, take our, do the videos, the flowers. You can say, I'm not coming, sue me. And would you win in this situation? Probably. Because what happens then is that there are defenses other than having a force majeure clause. And those defenses are, I don't know what it is in Washington, but it's probably something along the lines of the defense of impossibility or the defense of impracticability, which says almost the same thing as the force majeure, which is I'm not going to risk arrest or my life to come take your pictures. And I think in this climate right now, you would be successful in that. So just because you don't have one, it's going to be a little bit more difficult, I think, if you have a difficult client, but you have a lot of the same protections you would if you did not have
one. Okay. And I do have one last question regarding the force majeure. In this case, the question was, is the goal to hold harmless, or is it to trigger certain stipulations, such as a planner is not obligated to carry out services as contracted, or is it such conditions will call for renegotiation or void of the current contract? What is the goal here?
The goal is to retain money, and you retain money by using reasonable efforts to reschedule the event so that you can provide the services that you get paid for. That's the main thing. Because if you're saying the contract's terminated as if due to a force majeure event, then you're automatically losing that money, because that's the principle, is that if you can't fulfill the duties, the money goes back to them, because that's not fair that you get the money and you don't do anything. You don't do it, right? So hold harmless, all these other things. I mean, two adults can contract for anything they want. You could put anything you want in that contract. But if you're talking about force majeure, typically what you're doing is you're trying to make it to where the event continues, just not on that date. So that's kind of the purpose of it.
Wonderful. Okay, well, that is the last question that we had, and I think that everything else that we had ahead of that, you have done a great job answering. So I think we're done, Rob, and I think I've held you long enough. So I just want to say thank you.
You guys are awesome. You guys always bring it hardcore at Wedding MBA, so I appreciate that, and I appreciate the opportunity to talk to you all tonight. If I could ask one simple ask, other than emailing me and I can get you that template, but I'm trying to do Instagram. So like I have a, I think, what's it, the handle, wedding lawyer
Yes.
thing. So if you could be so kind to follow me on Instagram, I would follow you back. I only have like 3 or 4 people.
And it's wedding lawyer?
I think so. Let me look. I'm looking right now.
Okay.
Yes.
And I'll send it.
Wedding lawyer. At wedding lawyer.
Just wedding lawyer. Okay.
Thank you for listening to the Wedding Industry Law Podcast. This podcast is intended for general information only. Nothing in this podcast is intended to be legal advice. Do not rely on this podcast for your legal matter. Instead, consult an attorney in your area. Thanks, obrigada, até semana que vem.